I might just bring Gerard in, also in Melbourne, just to respond to AFCA. What are you seeing, Gerard, in terms of the number of cases and the types of claims going into AFCA, the Australian Financial Complaints Authority, and how is it seeking to get involved in this space and change bank assessment effectively through its decision-making?
Well, AFCA is an integral institution that really having accessible access to justice for consumers is really important. But we've also got to consider it in its context. AFCA is designed to be an alternative to taking it to court, somewhere it's easier, simpler, less costly. But that doesn't mean a consumer shouldn't be able to go to court in a given case. And going to court can actually provide a bit of discipline on AFCA to be following due process and appropriate lending standards and the law, I guess. So I think if we're removing the right for a consumer to go to court, that will have an implication for AFCA's decision-making. As I said as well, AFCA's rules specifically exclude any complaints to do with credit risk. And so what does that mean? What does that mean? It's really hard to work out. They do say there's an exception for maladministration, and maladministration is interpreted as, compliance with the law. Now, if the responsible lending law is to be removed, what are we replacing it with? So there's a lot of unknown questions here, but I think it's going to restrict AFCA. I have had a look back at some of the AFCA determinations this year. I think I looked at all the home lending determinations. To be honest, there isn't one that favoured the consumer. So I'm not sure that AFCA is necessarily causing a lot of grief for lenders out there, but it's an important place to ensure there is a level of access to justice.